You're back with The Nation and our extended interview with Environment Minister Amy Adams. Before we raised the issue of the Resource Management Act with the Minister, we played her a clip of an interview we did last week with Guy Salmon. He's a former National Party candidate and long-time environmentalist. This is what he had to say.
What's now happened is a very dramatic proposal for changing the purpose and principles of the Act in a way which is much more disadvantageous for the environment. I mean, I've worked with every Environment Minister since the first one was appointed, Duncan McIntyre, back in 1971. And this is the first time I've ever dealt with a minister who's been wanting to lower environmental standards. This shouldn't be happening in New Zealand.
Oh, Minister, how do you respond to that? Guy Salmon says you're the first minister who's moving to lower environmental standards.
Look, I don't accept that at all. What we're proposing in the changes to Section 6 and 7 of the Act, which is the purpose and principles section, is off the back of expert, independent, legal and technical advice the government received, which suggested that the portions that are being removed were unnecessary duplication and didn't add anything to the protection. I think what Mr Salmon and some of the other commentators are really upset about is that we are proposing that matters such as providing enough land for housing affordability purposes, providing for the consideration of the positive benefits of proposals, providing for the necessity of providing infrastructure, all be weighted and considered alongside environmental considerations. And in their view, the environment should be the first ranking consideration and everything else should be secondary. In our view, everything should be considered together.
I think his concern more is a little bit in parallel with the Greens at the moment, which is to suggest that the changes that are being made to the RMA is, rather than to enable big business, the changes are being made to favour big business.
Well, that's what they claim, Rachel, but they really haven't put up any evidence to support that. As I've said, the changes we've made or we're proposing to make to those sections are the ones that have been recommended by some very well-respected practitioners and commentators in this area. And I do acknowledge that we are proposing that all the impacts of any proposal, whether they're negative or positive, be considered side by side. And that seems to be what they're using as the basis for claiming that it is more developer-friendly and somehow lowers environmental standards. I completely reject that.
Well, I think they would also argue that the reason that they think it favours big business is because essentially you're taking it away from the court system. You're taking the rights of people to appeal this. They're losing those rights.
No, they're not at all. So there will still be appeal rights on all consent decisions. We are proposing that they change from what's called de novo appeals to the normal merit appeal on rehearing. There will still be appeal rights on plan processes. The only change we've proposed, significant change to the structure of the appeals, is if councils, regional and district councils, agree to go through a fully collaborative, integrated plan development process and go in front of an independent hearings commission, a panel to approve that, then the appeals on that point alone would only be to points of law. For everything else, there will still be merit appeals.
What about the proposal to declare projects of regional significance as opposed to just national significance?
No, well, we've still said that there will be the projects of national significance. What we've proposed in the bill that's before Parliament at the moment is that if projects are particularly large and involve a considerable amount of resource, then applicants will have an ability to refer the project straight into the Environment Court for consideration. Many times, and perhaps most times for those large projects, they will end up in the Environment Court. There is already a process they can ask the Council for permission to go straight to the Environment Court. This is just clarifying that for very large-scale regional projects, there is a right to go to the Environment Court directly and have the consideration heard there once.
And can you see that happening with the Ruataniwha Dam, for example?
Oh, well, again, I don't want to speculate on what process that might follow because the applicants haven't made any approach yet, so that's for them to decide what process they want to go down. But there will be a number of options that they will need to consider in terms of which is the best fit.
Earlier in this interview and in Question Time this week, you said you had been taking advice from outside the government on the RMA. Who have you been speaking with? Who's been advising you?
So we've had a number of advice streams that have fed into this proposal. We have had two technical advisory groups report to government on aspects of the reform package, including the changes to Section 6 and 7. There was a discussion document in the previous term of Parliament entitled Building Competitive Cities, which particularly looked at some of the urban design issues. And of course, we work with a wide range of stakeholders, practitioners, the local government sector, environmental groups. I met with a group of them just earlier this week. So we talked to a number number of groups, and we get feedback from around the country, obviously, in terms of frustrations and what is working well and what isn't.
And as part of those frustrations, did you speak with mining companies? Did you speak with Bathurst, for example?
I haven't spoken with Bathurst, no.
Has anyone from your ministry spoken with Bathurst?
Not to my knowledge, but I'd have to check with them.
Bathurst has now its consent. It's all but consent. It's just released that in a media release. What is the problem then with the RMA? Because it seems in this case it's working. It's gone through the due process.
And that's exactly the point, I think, is that there's a process and a decision will be reached, and that needs to be a robust process. But I would argue that the considerable amount of time and money that it's taken to get to that decision point is something we need to be concerned about. And it's not just the cost to the applicant or to the developer. There has been a huge cost on those opposing the project and a significant cost on the local councils who are involved in the project. And I think we can and should have a system that allows us to get to good quality, robust decisions in a much more timely and cost-effective way.
And that brings us again, though, to the issue that the RMA does, rather than enable business, does tend to favour big business. This will help the likes of Bathurst go through the system a lot faster.
Well, going through the system faster is a good thing. Whether or not their decision at the end of that is yes or no it depends on the merits of the proposal. And I don't accept that it favours big business, but what I do absolutely agree is that the RMA needs to consider all of our societal values, including issues like, do we have enough land available for residential land supply? Is land supply driving up house prices? Are there enough opportunities for job creation, and are we doing enough to support that? Do we have the right roading network? Do we have the right infrastructure? And those are all absolutely valid considerations under the Resource Management Act.
And it sounds though then the RMA is going to be leaning a little bit more to having an economic focus rather than, strategically having that environment focus.
Well, the RMA has always had the purpose of being both environmental protection legislation and our planning law. So it replaced the Town and Country Planning Act, and this is the framework under which we have to make all of our community planning decisions. And the vast majority of what goes through consenting is around what you might call those planning issues and don't have a significant either use or impact on our shared natural resources. So it's absolutely appropriate that the RMA should consider how we plan and whether that process is working well. And in fact, that the balancing of environmental and economic has always been a feature of the RMA.
There are two industries, though, that do seem very likely to benefit from these changes. One of those is dairy and the other is mining, because these are two industries which do tend to clog up the courts, don't they?
I don't see how you can say they will benefit from the, Rachel. If the processes are shorter, everyone benefits from that. So the issue of concern to people is whether the final decision is a yes or a no, but everyone benefits if the process and the time and the cost to get to that decision is reduced. There is a huge impact on communities, councils and objectors having to fight for years and years and years to get that final decision. I don't see it as a particular benefit to any sector of getting to that decision more quickly. I see it as a benefit for us all.
I guess because a lot of people would say that streamlined, which is essentially what this will be now, is a little bit of code really for fast tracking.
Well, I absolutely say that we want to have a process that doesn't take 3, 4, 5, 7, 8, 9, 10 years to get decisions. We want to have a process that gets to robust, sensible decisions that balance all of society's needs and concerns, and that has a process that everyone can engage in. You can't have a process where simply having the biggest checkbook and being able to outlast others is the determining factor. And I think in that sense, shortening the processes are a good thing.
OK, so where do these changes then to the RMA, where will they leave the Land and Water Forum? Because this is quite an interesting beast in that it's brought so many different groups and so many different factions together. They've collaborated. We're talking about tourist operators, dairy farmers, iwi, and that's been based on the existing RMA. Does this potentially blow apart that collaboration now, these changes?
Well, I certainly agree with you that the Land and Water Forum has been a fantastic initiative that we brought together and has actually given us a platform for making some real progress around water management. I think where we've been intending to head with the RMA has been well signalled. Some of it was in manifesto and supply and confidence agreements. Other parts I mentioned, the various technical advisory group reports that were well signalled that we were seeking and in fact were released before the final Land and Water report came out. So I think that's been reasonably well signalled the sorts of changes the government was looking at making. But one point I think think is worth making very clear is that the Land and Water Forum reports and the freshwater proposals that come off the back of them are around how we develop our rules around managing fresh water. That is then fed into the wider resource management plan and maintains its shape. So the rules around developing those water plans are still paramount. The National Objectives Framework and the national bottom lines to protect water quality that we're proposing will still be paramount, and that is the basis on which the decisions around fresh water management will be made within that wider umbrella of resource management that, as I said, covers a vast array of things, many of which are around urban planning.
Environment Minister Amy Adams.